Hi, everyone. I hope you can all hear me. I'm Nthabiseng Kotsokoane. I'm your moderator for the webinar today. Our webinar today is on e-resources during COVID-19, copyright and licensing issues. As you know that there is a pandemic that has closed our library doors and has forced us to find ways to really serve our communities online. It has pushed us to really be creative. And as you know that AFLIA had a survey where we were just checking the emergency preparedness of libraries around Africa. So the webinar today is a result of that emergency survey that we ran as AFLIA. I hope you will learn quite a lot from the webinar today. And you know that all the institutions and all our libraries, we've been receiving emails and of all sorts of online resources that are freely available for now. And after the pandemic, we don't know what's going to happen. All institutions are asking, do we have to pay? How do we deal with this? How do we negotiate? How do we renegotiate the terms of licenses? So today we have a very knowledgeable colleague, Teresa Hackett, who is going to take us through the copyright issues in libraries. And she's worked, she's got extensive knowledge in our continent also, because I know for a fact that she's been influential in some of the African countries when we were looking at our copyright laws. So I have a couple of housekeeping rules. I always say this. So I know there will be new people who don't know what we normally do, but for the sake of the people who are joining us for the first time, please, microphones off. We would like only the moderator and the presenter to be able to speak. Please, all your questions that you have, put them on the answer and question section. We will answer them all. Okay, I nearly said all. We will attempt to answer all of them at the end of the session, like 15 minutes before the session ends. We are going to provide you with the slides. Everyone who has registered is going to be given the slides of and the recordings of the webinar. We also have a YouTube channel that is where you can get all the AFLIA webinars. We are also streaming on Facebook for those people who didn't manage to register, or if you have issues with your connection in Zoom, you can watch via Facebook Live. And you can also ask questions from Facebook Live. We will take the questions and put them on the question and answer. The moderator, who's myself, will read them out, and then Teresa will be able to answer them. I think that will assist you. I have a team of moderators with me. They won't be talking, I'll be the only person talking. So they will be answering all the questions that we can answer while our speaker is presenting. So I hope you enjoy this webinar, and I hope you all safe and your families are safe. This is a really challenging time for all of us. I'm going to introduce to you my colleague from Eiffel, Teresa Hackett, who will be our speaker for today. I must say this has been a good topic for all of us. It came at the right time, and I feel comfortable handling it because, as you know, I'm a I work as an acquisition librarian at the University of Free State. I'm also a chairperson of Africa section and also a AFLIA governing board member. So I'm proud to be, and a proud LIASA librarian. And I hope everybody who is here is a proud member of their association. And their association is proudly a paid up member of AFLIA and a paid up member of IFLA and a paid up, we all paid up members of our association. You know, our association can only strive if we support them. Now I will introduce Teresa. She is the copyright librarian. She's a program manager at IFL. Teresa has overseen a delivery of unique copyright services for libraries in IFL partner countries. I've already mentioned that she worked with Africa, and the development of copyright resources in multiple languages and the provision of technical assistance on legislation matter. At IFL, she also helped to grow a dynamic network of specialist copyright librarians. We have one of them online, Kathy Machika from Zimbabwe, in over 30 countries, and many whom have achieved success in improving national laws. She participated in negotiations at the WIPO. Let me just leave it at that. If you don't know what WIPO is, I will be worried if you are a librarian and don't know WIPO. She works at WIPO and represents librarians, and when there's discussions of copyright laws. And she also makes sure that there's consistency on the laws across the borders, and that the public interest and the role of libraries, especially in digital environment, is represented at WIPO. She also contributed to 19 member states that are joining WIPO's Marrakech Treaty for the persons with print disability. Also here, I'll wear my hat as a Africa section chair. Please make sure that your countries are working, know what the Marrakech treaties are, and they all have ratified the Marrakech treaties. Prior to joining IFL, Teresa was a director of the Albida and a consultant at the European Commission's Library Research Program and electronic information service manager at the British Council in Munich, Germany. Teresa was also a committee member of the Copyright and Other Legal Matters section. She's also received quite a number of awards. In 2018, she received an award for her work on the copyright issues for libraries and was awarded the IFLA Medal in recognition of distinguished contribution to IFLA and international librarianship, particularly in the fields of copyright and enabling equal access to information. In 2015, Teresa was also awarded a flash grant as an agent of social change by the Shuttleworth Foundation for her copyright work. I'm very proud to present Teresa Hackett. Over to you, Teresa.
Okay, well, thank you very much, Nthabi, for that very kind introduction. And also thanks to AFLIA for inviting me to talk to you today about copyright and COVID and all the issues that it has raised for access to educational resources. I hope that you can all hear me. I hope that I'm speaking clearly. If you can't hear me or if I'm going too fast, please raise your hand in the chat and one of the moderators will get a word to me and I'll slow down. So, yeah, here we go. So I would like to start the presentation by giving some context for the work. So why are we talking about these issues today? Well, At the end of March, over 1.5 billion learners all over the world were affected by the closure of schools and universities. These closures, as you know, happened overnight and midway through the academic year. So there was no chance for teachers or students to prepare for the changes. So in order for education to continue, it had to move off campus and online. Even in this situation, copyright law still applies. So the question is, how do our copyright laws and our licenses for e-resources support education and learning in these changed times? And are some countries better equipped than others to respond? And these were some of the questions that very quickly came up among the library community. So in my presentation, I'm going to cover two activities that were immediate when the pandemic started and our institutions closed down. The first is remote teaching, and the second is online story time. And what I will do is we'll look at the rule books that govern access to the learning resources for these two activities. So that's your licenses for electronic resources and your national copyright law. We will briefly look at the copyright laws in Africa, and then we will look at the situation in Europe and in the US as a comparator. And then we will look at some advocacy efforts to help to fix copyright for education and libraries where the laws are not meeting the needs of our institutions. And then finally, I'll provide for you some resources and some tools that will help you to evaluate the situation in your own countries. So the challenge for librarians at the beginning was that the rules for online use of copyright protected content might be different from the rules for face-to-face use. So copyright librarians had to quickly assess the impact of this new situation according to the national copyright laws and to the applicable licenses. And depending on the material that's in question, that usage is governed either by copyright law or by contract law. So contract law being the license. Now, so first of all, I'm going to look at the licenses. So your licenses for your electronic resources. Typically, commercial e-resources are subject to a publisher license that sets out in great detail how the content might be used. So you should check the standard terms and conditions in your licenses for any restrictions relating to remote access or online use. In March, the International Coalition of Library Consortia issued a statement on the pandemic and its impact on library services and resources. And they asked publishers to temporarily lift certain usage restrictions. So for example, campus-only access, or limits on the number of simultaneous users, or any restrictions on document delivery. And if you look at that statement, it might give you some ideas as to the types of conditions in your licenses to look out for when you're looking at the license and how it affects access to remote teaching and online access. And the statement is available on the ICOLC website. Now, many publishers generously responded. So they waived restrictions on concurrent access. They allowed remote access if not already permitted. Some publishers lifted paywalls on the COVID-19 content, or sometimes to the entire portfolio of resources. This expanded access is set to expire at different times, depending on the publisher and the territory. So some publishers the access will expire by a certain date, maybe the end of July or the end of October. Other publishers, the expanded access will expire at the end of the pandemic. ICOLC is keeping a list of all the publishers that are providing expanded complementary access. So in addition to the terms in your standard licenses, you should also check this list to see if any of the e-resources that you are subscribed to have expanded access, under what conditions, and for how long. I would also like to mention, very importantly, open access resources. Because if your e-resources are subject to an open access license or an open educational resource, happy days. Because users can copy, download, distribute, print, use online without barriers. So they are the licenses that are the least restrictive and really will give you, will provide the ability to do remote teaching and so on. So now we're going to look over at the copyright law. So for the other resources that are not subject to a license, typically printed material, you should check your copyright law for any applicable exceptions and limitations, also known as user rights. Now, what are these exceptions? Exceptions to what, you might ask? Well, they're exceptions to the exclusive rights granted in the law to authors or publishers to authorize or prohibit certain acts. So in the context of our discussion today, when we're talking about the two topics, remote teaching and online story time, there's basically three rights that come into play: the right of reproduction, making a copy, the right of communication to the public, providing online access, and the right of public performance, performing a work in public. So I thought, as a starting point, I would take a piece of work that was done last year by Education International that evaluated the copyright and educational activities in 10 countries in Africa. And a couple of the activities they looked at involved online usage. So like a teacher wants to email reading material to students, or a teacher wants to share an article on the school's network. And according to that evaluation, a couple of countries, so 3 countries permitted these activities, 7 countries looked like, according to their laws, that they didn't permit those activities. So I thought we could take one of the countries in the yes category and one of the countries in the no category, and then we can look at the activities, we can look at the laws against the remote teaching and online story time. So for remote teaching, which is where teachers display works during a streamed or recorded online class accessible to the students, there's generally 3 steps required, generally three exceptions that might be needed. Generally, there are some exceptions, but in general. So first of all, you might need an exception to the right of reproduction. That's to make a digital copy of the printed item. So that's assuming you have a printed item, it's not in digital format, it's in print format, and you need to get it online, so you need to make a digital copy. So if we look at the copyright, looking at the copyright law of Ghana, this is allowed, digital copies are allowed, but it is subject to conditions. One of those conditions is that the exception is limited to extracts or short works. And in this context, where teachers might want to use larger amounts of material, that's quite a limitation, and that might not be so helpful. So for example, if the school books or the textbooks are all in the classroom and the school is closed and the kids can't get into the classroom, then the teacher might want to copy the whole textbook to use it with the children during the time of the pandemic. In Mozambique, the digital copying arguably is allowed. There is an exception for copying by reprographic means, which means including facsimile copies. So arguably, digital copying is indeed allowed, permitted in Mozambique. The second exception to the right is the right of communication to the public, so to provide online access. So this is your core exception really for this purpose. And in Ghana, there is an exception in section 19 of the copyright law. In Mozambique, there is no exception per se to the right of reproduction, right of communication to the public. The educational exception states that a work might be used by way of illustration in publications, broadcasts, or audio or video recordings. So it might be possible to argue that transmission over the internet is a broadcast, as it is defined in the Act. On the other hand, it might be hard to argue that illustration applies to a book chapter or a textbook, maybe to a newspaper article or something quite short, but might be harder to argue for, for a longer piece of work. So that might be a little bit tricky. And then the third exception that may be needed is an exception for so-called cache copies. So these are the temporary copies that are created automatically as part of the online transmission. In Ghana, there is an exception for cache copies. In Mozambique, there is no exception. So I hope you're keeping up, hope you're all with me so far, and that you're hearing me well. If you're not, please leave a message on the chat. So now we're going to move on to the second topic, which is online story time. So this is where librarians and other facilitators are reading aloud books to children over the internet during a live stream session. So for online story time, the relevant exception in your law is the right of public performance or communication to the public. In Ghana, there is an exception for utilization of a work for professional training or public education, subject to two conditions: fair practice and indicating the name of the author. So that's fine, no problem. In Mozambique, arguably, online story time is allowed. For sure, face-to-face story time is allowed by staff and students in educational establishments. So that would be, for example, teachers and maybe school librarians, where there is a librarian attached to the school. But of course, that means it wouldn't apply to public librarians, even in a face-to-face situation. Not sure that the legislator intended that to be the case, but on a reading of the law, that's what looks like what the law might be saying. So a mixed situation, not bad, overall not bad, a little bit mixed, some ambiguities in the laws. So now we're going to look briefly at the situation in the EU. As far as remote teaching is concerned, this is permitted in some countries. So the 2001 InfoSoc Directive, which is the EU framework legislation for European member states, has an education exception. But the problem is that the exception is optional and not all member states implemented the exception. Now, the good news is that under the more recent directive on copyright in the digital single market, which was adopted in 2019 by member states, there is an exception for education and it is mandatory, which means that all the member states have to implement it. But the problem is that this new directive is not yet implemented in any national laws. So as a matter of EU law, at the EU level, we have that mandatory education exception, but it hasn't yet been applied into the national laws. So it's tantalizingly there, but not yet implemented. For online story time by librarians, again, we have a mixed picture. Some countries enable it. It is allowed under the InfoSoc Directive from 2001, but the problem is that more than a quarter of member states didn't implement the necessary provisions. And then even the member states that didn't implement those provisions didn't always include librarians as beneficiaries of the education exception. So it strikes me that as librarians and educators, we should work, more closely to ensure that these provisions that would apply for education also apply to libraries and vice versa, for librarians that are supporting educational activities. As a result of this mixed situation in the EU, The Association of European Research Libraries, LIBER, published an open letter to the European Commission and to member states in April, asking for urgent guidance to ensure that researchers and librarians are able to fulfill their educational responsibilities and to provide remote services during the COVID crisis without fear of litigation. And in their letters, they gave examples of some of the activities that can constitute infringing behaviour under the law. So, for example, teachers scanning entire textbooks for online courses, and public libraries reading whole books as part of story time for children. Also sharing, researchers sharing protected work online. So what is the situation in the US? Well, in a nutshell, remote teaching and online story time are covered under the US Copyright Act. So there are specific exceptions in the US Copyright Act that permit use of works in remote education and reading aloud for face-to-face instructional activities, Section 110. Now, Section 110 also makes clear that educators can look to this general fair use provision to extend long-standing practices into new digital settings. So that's Section 107, fair use. And during the COVID time, responsible application of fair use has enabled a number of important activities. So, for example, educational institutions are able to migrate their courses online during the pandemic. And it's allowed libraries to offer programs such as online story time without challenge from rights holders. And at the start of the lockdown in March, some library copyright specialists got together and made a public statement on fair use and emergency remote teaching and research, where they reaffirmed the role of fair use in supporting remote teaching during COVID. And where they said that fair use is made for just these kinds of contingencies. So contingencies for situations that could not be anticipated. And that the doctrine of fair use accommodates the flexibility required by the public health crisis to enable teaching and learning to continue. And that statement is available, it's available online, and I've given you the link at the end. So I've mentioned a couple of times, I've mentioned fair use just now with the US, and I mentioned fair practice in the context of the copyright law in Ghana. If you remember, that was one of the conditions of the use of the digital copying exception. So I wanted to just set out for you the differences between fair use, fair practice, and fair dealing, because these are three terms that you hear quite a lot about. They appear in lots of copyright laws around the world, and they are three distinct legal concepts with specific meanings. So I'm sorry for all the text on this slide. I hope it's not too small. It's really for reference, because I wanted to get everything onto one page so that you could see what are the differences between those three concepts. Fair practice can be found in the Berne Convention, the 1886 convention that was the first international copyright treaty. And it's a standard, so it's considered to be an objective assessment of fairness for what's normally considered admissible. At the end of the day, it's up to the court to decide what's fair practice in that particular situation, in a particular country. They might look at things like the amount that's been copied and if the use has harmed the market in any way. Many copyright laws have fair practice in their law. And many countries in Africa, maybe 10, 15 countries at least in Africa, have the concept of fair practice in their law. Fair dealing, on the other hand, is an exception. So it's a general flexible exception, first developed by the English courts in the 18th century, and then incorporated into UK law and many national laws, including former British colonies and overseas territories, including in the copyright law of my own country, Ireland, fair dealing. So fair dealing is typically set out as fair dealing with any work for the purposes of specific activities, so private study, research, criticism, review, or newspaper summary. And these shall not constitute an infringement of copyright. Fair use then, in the US, is where fair dealing evolved into fair use and was codified in the US Copyright Act of 1976. And fair use permits use of a work for purposes such as criticism, comment, news reporting, and so on. So it's an illustrative list. It's not a closed list. Then in determining whether a particular use is fair, the court considers 4 factors. So the purpose and character, the nature of the work, the amount of the work, and the effect of the use of on the market of the work. So fair use is generally considered to be more flexible and open-ended than fair dealing, but this is changing because many countries are expanding their fair dealing provisions or introducing fair use into their law. So many countries in Africa have fair dealing from, coming especially from the English Copyright Act. A couple of countries in Africa do have the phrase fair use in their copyright law. So there's Gabon, Liberia, and Uganda. Now, looking at the laws, probably Liberia is the closest to the US style fair use, but it is appearing in more copyright laws. So, looking then at what are some of the lessons that have come out as a result of the COVID-19 with regards to copyright and licensing. So I would say that there's a heightened awareness of the importance of copyright exceptions. There's been a lot of analysis all around the world of librarians looking at their copyright laws to see what are they allowed, what might be allowed, what might not be allowed in their law. And also the benefits of a flexible fair use style exception that can provide a safety valve in times of emergency. So it gives some support to activities that are needed during the times of the emergency to provide emergency access to learning resources. Second, I would say it's accelerated debate among librarians who don't want to operate or are not comfortable operating in legal grey zones to support the important public service missions of their institutions. Who don't want to have to, working in legal grey zones, maybe under fear of litigation, but in order to provide access to essential learning resources, they may be forced into this situation. And the third thing would be that a reliance on temporary fixes and the goodwill of publishers during COVID, while this of course is very welcome, highlights the need for a really robust legal framework that supports access to knowledge and the fundamental right of access to education. And then finally, I would say would be the importance of copyright literacy. So knowledge of copyright, knowledge of your law, knowledge of your licenses, in order to help you make informed decisions. And then the role of librarians in helping teachers and students to navigate their way through these legal issues. So librarians in many institutions were being asked questions, and I'm sure many of you in your own institutions were being asked, can I do this? Can I do that? I need this book for my students. I need to be able to provide access to this. What is the legal situation? So getting to know your copyright law, getting some basic knowledge of copyright and your licenses, I think is very important, because knowledge is power, and a well-grounded risk assessment is part of the game in copyright. So I think now would be a great time an opportunity to start looking at these issues in your copyright law and to advocate for copyright law reform where your law is not maybe meeting the needs of your users. So first of all, get the facts would be to review your law for library and educational activities to identify any gaps or areas that might need to be improved. There is help available for this, and we can talk about, you know, maybe more about that later. But I think the first thing is to find out what is the situation in your law in your country. There is strength in numbers, so bring in your library association or your library consortium into the discussions. Connect with the education community, especially your teachers' unions. So we've been quite active working with Education International at the international level. So the education community can be a great support. Also bringing in examples of activities that are needed in the classroom. And then would be to raise awareness of copyright and access to knowledge issues within the community. And then finally, engage with your government authorities. So advocate for change with your National Copyright Office, your Ministry of Education, any other ministries that are involved in delivering education and library services. Because as library and educational professionals, you are the experts in your field. And it's very important that you can explain to the copyright officials the activities that you need to do, and then make suggestions for how the copyright law might be adapted. But you are the experts in acquiring information about licenses for e-resources, about the types of materials, about the types of ways that your students are accessing material. And that's very important information that your copyright officials understand and that you can explain to them. And then at an international level, it would be really great to support the community with international copyright law reform at WIPO. So WIPO, mentioned by Nthabi at the beginning of the session. WIPO is the the World Intellectual Property Organization. And libraries and archivists and people working in museums and education are advocating at WIPO for international copyright law reform. So we're looking for, asking for an international legal framework that will put in place a basic framework to allow for all these activities we've been talking about in every country around the world. In the form of a treaty or a binding international instrument. Now, we've, last year in Nairobi, there was a regional seminar organized by WIPO on copyright limitations and exceptions for libraries and archives. We had a great team there. And then later in Geneva, there was an international conference on the same issue. And the Standing Committee on Copyright and Related Rights is discussing limitations and exceptions for libraries and archives. And the communities have made proposals for treaties, a treaty on libraries and archives and a treaty on education, to try and put in place some of these basic framework that we need at the international level. Then I've also put together for you a resource list where you can find out more information. So if you're new to copyright and you'd like an introduction to copyright, there's a couple of resources there that might help you. Also, sources where you can find out information about your own copyright law. So WIPO Lex is a global database of national copyright laws, so it's a kind of a handy place to start where you can find all your legislation. Of course, do check if it is the most recent version. So you could check with your copyright office, or maybe locally you might find if there's a more recent version of your law online. Two studies that I would recommend are the WIPO study on exceptions for libraries and exceptions for education. So the study on libraries by Professor Cruz, for example, has a handy table for each country where it sets out in a nice short format what different activities for research and study, or for preservation and replacement, and for education as well. So that might be a handy place to start if you just want to get a quick overview of what does your law allow. Then we've also got some infographics which were prepared for the regional seminar in Africa last year on libraries and on educational activities. And there's a number of tools that are available as well. So at IFL we have a tool that we call Rate My Copyright Law, where we have a list of questions, and you can evaluate your copyright law against those questions and then rate it and see to what extent does it support the copyright law. We've also got a draft law with model provisions for libraries and archives, and some articles on why we need a single global framework, and some articles on copyright reform in Africa as well. A number of articles also on fair dealing, if you want to read up more about that, fair dealing and fair use. And then both IFL and IFLA are active at WIPO, and you can check out our pages and see how you can get involved in those issues. So with that, that's the end of my formal presentation. I'd like to see, I'm just checking in to see, are there many questions? Madam Moderator, could you perhaps let me know how are we doing with questions? And we have a colleague online from Zimbabwe, my colleague Kathy Matsika, who is available to talk a little bit about advocacy in Africa. If you'd like to move on to that, or if you'd like to take the questions first, up to you. Thank you.
I will take questions, and Kathy can be ready in the meantime. We've got quite a number of questions. I will try and put together the ones that I think are similar. Okay, the first one is, can we keep the book to learning? Okay, somehow I have to rephrase. Can we keep the e-book to the learning management system? I'm thinking this means, can we put an e-book on a learning management system?
Okay, well, that depends on your license. So you should check, if you have an e-book, you will have a license for the e-book, and you should check your license and see, does that allow you to put the e-book on the learning management system?
Okay. And the second one is, kindly explain if someone uploaded copyrighted book on the internet and one is downloading ebooks from the internet. Is it violation of IPR? If yes, how? Also explain the legal aspect of this. From my brother from India, Kumar.
Okay, so the question is about uploading in copyright books to the internet.
Yeah.
Okay, so
and it says if it's uploaded to the internet and one is downloading ebook, he downloads those ebooks. Is it a violation of IPR? If yes, then please explain.
So I suppose there's two questions. So if the book is in copyright, presuming it's not an open access resource. So if the material is open access, then of course having it online or downloading it, you can do according to what the license says. If it's like a book, a print book that's been scanned, then that will depend on and it's been uploaded to the internet. Depends on the national copyright law. Possibly in many countries not allowed, not legal, but depending on the national copyright law. But in many countries, if it's an in-copyright book and it's being uploaded to the public internet, that would generally not be permitted.
Okay, I think he's from India, so I think he needs to also to look at the copyright laws in India. He
Yeah.
also he has a follow-up question on, is there a free course on IPR?
Well, are there free courses on IPR? There are courses on IPR, and in fact, there's IFL has an online curriculum, so it's not an actual live course, but it is a curriculum which is online, so you can follow that yourself. There's a number of courses also online. So Terry Fisher at Harvard Law School had a number of, there's a MOOC which is online for copyright issues, and also WIPO does an online course on copyright and all different types of IPR.
Okay, there's another one that's, what are the strategies for digital lending services at the time of COVID-19 crisis?
Strategies for digital lending services. Now, what do we mean by strategies for digital lending services?
Unfortunately, I can't let him talk, so I think I also don't understand. Okay, I will go to the next one while we think about it. Please clarify your question because we don't understand it. Yeah. There's another question from, it says, how can curriculum help to widen knowledge of copyright laws among library science students?
So I wonder, is this how can the curriculum in library schools?
I think, yeah, in library schools, I think.
Yeah. Okay. Well, I think it's really important that the students at library schools learn about legal issues to do with information. So including copyright and licensing issues. Because the moment that a librarian is working in a library, they are dealing with copyright issues. They're dealing with copyright protected content on a daily basis, and they're dealing with many copyright questions during the course of their work. And I think, as I mentioned at the end of my presentation, librarians have a really important role within their institution, as many of the librarians on the who work in the IFL network will know. They have become the go-to person within their institution for questions about copyright. And librarians can use their knowledge of acquiring information and having these licenses to become, an expert person within their institution, which raises the profile of the librarian in the institution and the library as well. So having librarians coming out, new librarians already familiar with these issues, is really important. And I think it's going to become a bigger part of library work as time goes on.
Okay.
And a great skill to have, and lots of opportunities. If you can get if you become knowledgeable in these issues, there's lots of opportunities for specialist roles and getting involved in advocacy at the national level and international advocacy at WIPO as well.
Okay. I think I'm taking the last question from India now. As an e-librarian, what should I consider when subscribing to an online database to ensure that such databases adhere to copyright law?
Well, if you're subscribing to an online database, so let's say it's a commercial database, then the license will usually come from the publisher. So the license will set out, the publisher will either own the copyright in the database, or they will have permission to act on behalf of the rights holder. So the license that you get is already a legal document. The copyright in the resources is protected, and the license is simply sets out what you, as the librarian and as the library, can and cannot do with those resources. And when you get such a license from a publisher, it is really an invitation to negotiate the license. So although the license may come from the publisher, you as a librarian have an opportunity to review the license and to make any changes to the license that you think are necessary for your situation. There are, of course, many model licenses out there. Library consortia have model licenses which can also be used, but it is a negotiation. And but the copyright issues are protected already through the ownership by the publisher, who has the right to offer this license to the library.
Richard, it says, what are the legal implications of uploading research article of staff in your university to an institutional repository?
So for an institutional repository, so the first thing is, before you upload material, you should have permission, either through an exception in your copyright law, or if you don't have an exception, then permission from the author. So if it's a material from a researcher, then you should normally have permission from the researcher to upload that material, and that permission can either be maybe on a one-to-one basis, or it might be something that's part of, when the researcher becomes part of the institution, it may be part of their employment contract, that material can get uploaded to an institutional repository, for example. But normally it would be regulated either by a permission or by an exception in your copyright law. But always a good idea to make sure that, you know, to agree with your colleagues about making material available online.
Okay, and then there's another question for Richard, How can we manage the access to the e-textbooks during the COVID-19 pandemic?
So managing access to e-textbooks. So
Yes.
that also implies, if I understand, that's a born digital material. So it's an electronic book. So for that, you will have a license from your publisher, or from the aggregator who has sold you the license. So you should look at your license. Look at your standard license terms when you signed the contract, when you signed the license. And then look at that list of publishers on the ICOG website that are providing expanded access. And then you will see what you can and cannot do with those e-resources during the time of the COVID. If you want to do something, you want to maybe put the e-resource on a learning management system, or do something that's outside of the license agreement, contact the publisher and ask the publisher, and maybe the publisher will give you permission.
Okay.
But check your license.
Yeah, I think this one has been asked by a number of people. Are there currently modalities of strengthening the copyright issues at WIPO? I think there's 3 questions similar to this.
Okay. So yes, there are. Well, there's modalities of strengthening user rights at WIPO, shall we say? I suppose the issue for libraries and educators is that the rights, the exclusive rights that are given to rights holders are international and mandatory. So they're set out in the international treaties. So those exceptions the rights that I mentioned that we talked about today, right of reproduction, communication to the public, and public performance, for example, are set out in international treaties. So we know that the copyright law of every country has at least those rights, mostly, generally. On the other hand, the exceptions to the rights, so the exceptions that provide access, the provisions that provide access, with a couple of exceptions, are generally optional, and they're set out at the national level. So that's why we have this kind of a mismatch of these rights that are granted at the international level, and they're mandatory, and then the exceptions which are set out at national level. Now I said that there were 2 exceptions because The Berne Convention includes a right of quotation and a news reporting exception. But generally, so the exceptions for libraries and for education would be at the national level. So that's why we as a community are advocating at WIPO to raise the level of these user exceptions, so that we have a better basic framework for countries all around the world. Because at the moment, copyright laws of every country are different. So it's like a mismatch, and that's why, like, looking at the copyright law of Ghana or Mozambique or the EU, they're all slightly different, and it's very difficult. So what we would like to do is to have a framework, a basic level playing field. And we're working at WIPO with the Standing Committee on Copyright and Relating Rights. They've been discussing limitations and exceptions for nearly 15 years. We started by talking about exceptions in general, and then we split it into topics. And the first topic that was talked about was exceptions and limitations for people who are blind and visually impaired. And that resulted in the Marrakesh Treaty for people with print disabilities. And so that was a great success. So we now have an international treaty that sets out user rights for people who are blind and visually impaired. And now we're talking about exceptions for libraries and exceptions for education to set out a basic level of provisions. And so we are advocating at WIPO, attending meetings of the Standing Committee, and making proposals to member states and working with member states. So I think it would be, for those of you who are interested, it would be very important and very helpful for you to contact your copyright offices and to talk to them about these issues, explain why they are important to you. And then when we go to Geneva, then we have that support from the member states.
Okay, I think after this question, Kathy, be ready. I'll give you a chance to say something about copyright in Africa. So Lashan has got a question. During lockdown, course packs have been produced for students that live remotely with limited or no access to the internet. What are the implications of the multiple reprography process with regard to copyright?
So again, it depends on your copyright law, your national copyright law. As to what extent you can copy, you can make multiple copies of course packs. Now, but I would say, of course, you know, it's important that I think we take a responsible approach and we take a common sense approach. And the types of questions that you should ask yourself. So if you check your law and see whether you think this activity might be covered within your law, it may well be, and that's fine, happy days. If it's not, then I would say to take do a risk assessment. So you would say, like, what is the likelihood that what you're doing infringes copyright? Okay. Is it likely to cause harm to the market? Would the copyright holder be likely to object to what you're doing, and would they be likely to sue you or your institution? So if you might say, well, these are resources that we made available to particular students, you know, for a particular reason during the pandemic, they were copied, they were given only to students that are part of that class, then you may have you can mitigate your risk. And if you have, for example, in your law, this fair practice provision, this fair practice standard, then you may be able to argue that these activities during this pandemic are reasonable and don't cause harm to the market. So it's maybe having a little bit of grounding knowledge about what the facts about your copyright law, and then looking to see how you can mitigate the risks, so that we don't we don't use the copyright law to sort of try and shut down all activities that are not allowed, but maybe that are not set out in the law, but that maybe we can mitigate the risk and act in a responsible behavior in copyright content.
Okay, there's I think this will be a quick one. How do you find the support provided during COVID-19 to US and Canada universities by ebooks and e-textbook providers, and not in Africa? I don't know if you have an answer for that.
Can you repeat that question?
It said, how do you find the support provided during COVID-19 to US and Canada universities, right? By the ebook and e-textbook providers. So it means there's a lot of ebook providers that are providing e-textbooks and ebooks to Africa. You know, the free access that I spoke about at the beginning, and they are not given the same to Africa.
Oh, okay. Yeah, no. Well, I wasn't, you know, particularly aware of a big difference between you know, US, Canada, and Africa. What I can say that in IFL, so I do know that the IFL licensing manager has been working very closely with publishers for IFL licensed resources, and has been negotiating expanded access to those resources, providing you know, password access instead of IP access, like lifting restrictions on the technical access, and also lifting restrictions on content as well. So I can't, other than that, I'm afraid I can't, I'm not aware of any differences. But do check that list on ICOG for the list of publishers that are providing expanded access. And, you know, if you're not getting access to some resources that you need, contact the publisher. Or if you're part of a consortium, contact your consortium and ask your consortium to talk to the publisher. And for IFL licensed resources, and for countries that are part of the IFL consortium, you know, feel free to contact the IFL licensing manager, who can try to help.
I think that will also answer the question about, there's someone who asked, how do they get the free access to the resources that have been made freely accessible? I know AFLIA also has got a list on the AFLIA website, so they can also go to that website. So, okay, another question is there actually a smooth relationship between copyright and open access?
Oh, very smooth.
Really?
That's it. Yeah, because open access is like complementary, and open access and copyright work very well together, because it's copyright that gives the author the right to decide on how their work is used. And then, so therefore, when the author decides, I'm going to make my work open access and license the work, so that license is being built on top of copyright law. So copyright law is like the base for everything, and then your license sits on top of the copyright law. So whether it's a license, it might be an open access license, or it might be a proprietary license from a publisher with restrictions. But in both cases, the licenses sit on top of copyright law, and it's copyright law that gives the author the rights to decide what to do with their content. So it's a very complementary systems, I would say.
Okay, another question is, does including screenshots from social platform within publications require permission?
Including screenshots. I mean, generally, again, it's your copyright law, but generally not. Particularly if you have a broad exception in your copyright law, not. I would say not.
Okay, there is a request that, can you please talk about websites like Sci-Hub and PDF Drive?
PDF Drive.
Yeah, is it PFD Drive or
PDF? Yeah, okay, I don't know that one actually.
Yeah, I know that. Yeah, that website and Science Hub.
Yeah. Well, Sci-Hub is a repository, I suppose. I mean, it's a source of it's an unauthorized site that contains material that's not authorized by the publishers.
Okay. So the PDF Drive.
I don't know the PDF Drive. I'm guessing it might be a similar one. I mean, I know there is on Twitter. There's a there's a hashtag #IHasPDF, and you can request material. I'm not sure if it's related to that.
Yeah, I think most of the students always say they've found a full text drive, full textbook from that source. But yeah,
Right.
I think we just needed to know, is it a legal or is it an illegal?
Ah, okay. So I'm sorry, I don't know the second one.
Okay.
The first, the Sci-Hub is unauthorized. But this is why we try to, we want to have, you know, reasonable copyright laws that allow reasonable access to make it easy for students and educators to get their material from authorized sources. And so if there are roadblocks and difficulties, then it kind of drives students away from the authorized sources and to the unauthorized sources. So by having a good, robust legal framework that allows reasonable access and seamless access, I think that will help. It will help everyone. It helps the copyright system. It helps, and it helps respect for the law when access is reasonable and fair.
Okay, there's one question from Nigeria. To what extent can copyright law inhibit library resource sharing?
To what extent can copyright law inhibit resource sharing? Well, it can inhibit resource sharing if your copyright law doesn't allow activities like document delivery, for example. But it can also facilitate if it allows resource sharing. Document delivery is one of those topics that is kind of quite dear to my heart, because I think it's a really important service. And when Professor Cruz did his study of limitations and exceptions for libraries and archives, the WIPO study, only about 10% of countries in the world have an exception for document delivery. So that's, I think that's one of the areas, that's one of the exceptions that we're advocating for at WIPO, to have an exception for document delivery. So the answer to the question is, like, copyright law can inhibit or it can facilitate if it has a provision in the law that allows for that activity.
Okay. As library professionals, how should we help our library user from disadvantaged background with no computers, smartphone, internet connection to e-resources during this COVID-19 pandemic?
Yeah. So that's back to the question, the issue I mentioned about risk assessment. I think we as librarians, we want to help the users, and we want to help people in disadvantaged situations, like you mentioned. So I think if you manage the risk, if you say in terms of the content, you can justify the content that you're providing. Maybe it's part of a course that the student is doing. So it's relevant and necessary to the education or to the course that the student is on. That you only provide the amount of material that's necessary for the student at that time. And that you include information about the attribution, so it's you know where the information is from and so on. You acknowledge the source. Then I think that helps to mitigate the risk.
Okay. Kathy, I'm just going to give you 5 minutes to say something about, so that we can give Teresa some time to breathe, because there's so many questions here. I'm handing over to you, Kathy.
Oh, hello.
Hi, Kathy.
Hi, how are you guys? Thank you for this beautiful presentation, Teresa. I think you've simplified a lot of things and clarified a lot of issues that a lot of colleagues might have wanted to hear from you. And in brief, I think us as professionals on the continent, we still have a lot of work to do, especially where it comes to advocacy, trying to get our governments or our authorities to understand the issues that are involved in copyright and libraries and archives and education. But what I think has happened with this pandemic is that it has brought the governments closer to the libraries. Now understanding what it means to provide information and how copyright affects the delivery of information. And I think it is right for us as librarians to take advantage, not that we are celebrating COVID or Corona in the pandemic, but we are seeing our role changing to the new normal of online education, of online teaching and providing information online. And we should then take advantage of the situation and clarify to our ministries who are singing daily about online education. I think they are listening now, and we need to take our issues straight to them and explain why librarians think the copyright laws should support the user. We know that a lot of African countries are perhaps looking at redoing their copyright laws, and I think we need to get this information out there. Whilst we're looking at Marrakesh, whilst we're looking at all the other exceptions and limitations that need to be added to the copyright laws as we revise them, I think we need to really emphasize what it can mean if our copyright laws are liberal, they are or are inclusive, they are helping our learners use the information that is available now online. I think as librarians, I think in copyright, we need to then use the kind of fora that we have like today, of talking to each other, advising each other, and even bringing smaller groups together within our countries to make sure that librarians really understand the copyright laws that are governing the countries. We need to actually talk to each other more often about copyright. We need to talk to our institutions, our academic friends. I think, again, COVID has brought the realities out into the open. They cannot do what they used to do. They have to learn to do the new things. And those new things are what was covered by Teresa of, can they include a chapter in a lecture and pass it online to their students? Are they breaking any laws? Our copyright laws, do they cover them? For example, in Zimbabwe, where there is fair dealing, can they do that? Those are questions that you can actually be taking to our colleagues in our institutions to make people understand the importance of respecting and making sure that they don't end up being involved in litigation because they've used copyrighted material. It is also good to talk to if you have a consortium, take it up at the consortium level. If it's a library association, talk to all the colleagues at all levels, including schools now. We know schools are now doing online teaching, online classes. Do the teachers at that level understand? Those are the kind of things that I think have actually come to the fore, and we need to take advantage of this situation as we see them. Do we need to change our laws in Africa? Yes, I think we need to. As Teresa said, at WIPO, there's an effort to try and improve the exceptions and limitations to make sure that the copyright laws are more friendly to the users rather than to protect just the authors and the publishers. So I think in brief, those are the things I think we need to actually take advantage of the time that we've been presented by this pandemic to make sure that our users and ourselves are in a better place at the end of the pandemic, to be able to utilize the online resources in a legal way without having to put our institutions at risk. Okay, my 5 minutes over.
Yes, thank you very much, Kathy. We're going to invite you back and a couple of our colleagues from the African continent, because there is a need on the continent for advocacy, especially on copyright issues and the Marrakesh Treaty and all that. So please, everyone that we haven't answered your questions, we're going to have a follow-up webinar on copyright issues. So if we haven't answered your questions, please email them to Kathy or Teresa. They will be able to answer you. Or join us for the next, the follow-up session that will be on copyright issues and advocacy. I'm going to quickly give up a few minutes back to Teresa, and she's going to talk about research and copyright. Over to you, Teresa.
Okay, thank you very much, Nthabi. Just a very quick, follow-up to what Kathy just said. So I'm working at the moment with the American University Washington College of Law, the program on information justice and IP, and they are doing some research at the moment on where they are evaluating the copyright laws of every country in the world according to the education issues that have come up as a result of the pandemic. So with that research, I think it'll be easier and it'll be clear to get an overview of what all your different copyright laws allow, and it'll be easier then to answer specific questions about what does your copyright law allow in terms of these activities, and where are the gaps, and where might we need to make some improvements. So I think that will be a very good piece of research. It'll be very useful to everybody working in this field. So that was, just wanted to mention that as well. And also then to thank you very much, Afi, and to thank you, Kathy, for your intervention. And Kathy, as a copyright coordinator in Zimbabwe, has been a great support and a great advocate for libraries and copyright issues in Africa and also in Geneva. So thank you very much for the opportunity.
Okay, thank you, Teresa. I actually wanted to say to you, I didn't introduce Kathy because she's my colleague in IFLA Africa. We work together. So I wanted you to introduce her. Thank you for doing that so well. Colleagues, thank you very much. I know we have loads and loads of questions that are unanswered, and I hope you will be back. Please watch your emails. There's lots to come. And please stay safe. Please stay at home. Please stay safe. Wash your hands. Do everything that your government tells you to do. Be safe. Please be safe. Thank you, Teresa, for a wonderful presentation. Thank you, Kathy, for jumping in at short notice. Yeah, that's what good colleagues do. It shows that Teresa has done a great job in Africa to advocate for copyright law. Teresa, we still need you in South Africa. Copyright law has gone back to Parliament, as I'm sure you are aware of that. And all the colleagues from the different countries, please reach out to our colleagues if you need help, if you need assistance with advocating for your copyright laws in your countries. Thank you very much.
Thank you, everyone. Thank you. Bye, Teresa.
Thank you.
Bye.
Thank you. Bye, bye, bye.
Thank you, everyone. The meeting ends now.